Thank you for coming in. Okay. Good afternoon. My name is Janine Biggins, and I'm your host this afternoon for the Washington, D.C. SCORE webinar on how to identify and protecting your secret sauce, protecting your intellectual property. Just a few housekeeping notes. The webinar replay will be sent to you within 24 hours. So that way, in case you have to leave early or you miss some information, you will be sure to receive the replay. And that way you can watch it as many times as you like to review the great information you are about to receive. In addition, there will be a few select slides given. The whole presentation will not be provided, but there will be some slides available. But again, like I mentioned, you can watch the replay as much as you would like. And I would like to introduce, let me just ask one more time to make sure everyone can still hear me. I would like to introduce our presenter for this afternoon, Barbara Berschler. Did I pronounce that correctly, Barbara?
Yes, thank you.
Great. Has since 1985 advised business owners throughout the Maryland, Washington, D.C. metropolitan area, as well as international clients. Ms. Berschler's practice consists of general business and commercial law, with a special focus on intellectual property law, copyrights, and trademarks. She has earned both a JD Juris Doctor and an LLM Master of Laws degrees. She was awarded the Brinks, Hoffer, Gilson, and Lyle Award for Excellence in Intellectual Property Law. So needless to say, this presenter this afternoon knows what she's talking about. And without any further ado, I'm going to go ahead and then just a little housekeeping. If for some reason you're having trouble with the audio or visual, at the bottom of your screen, there's a blue button and you can just click on reconnect and it will kind of refresh your information. Okay. So Barbara, let's start.
Thank you very much, Janine. I appreciate the introduction, and I'm very pleased to be involved in SCORE's project to produce webinars about topics such as this one. We have a great deal to cover in the hour we'll be together. So please understand that this is going to be a preliminary examination to enable you to be able to ask the right kinds of questions. You may not know the answers, but at least if you're aware that, hey, I have a question. Now, an overarching question is, you always want to ask yourself or whoever you're working with, who owns the intellectual property? Hopefully in the course of this hour, you'll get some clearer understanding, but it's not always the person you think. So let's get started. And the beginning is, well, what is copyright? As you can see from the slide, it speaks that there are exclusive rights that the law grants to the creator, also known as the author. You might also hear the owner of the copyright, but it's for a limited period of time. So once the time expires, then whatever that work is, it's in the public domain, and the author no longer is able to restrict usage. Now, what are those exclusive rights? Well, it's the right to reproduce or to copy whatever the work is, to make derivative works. And a derivative work is based on the original. So as an example, if somebody wrote a novel, they would be able to permit somebody else to base a play on that novel. The play would be the derivative work. Another right is to be able to distribute it. You send it out, you give it away, you charge for it. And then some of the activities are perform, display, and transmit. So that's covering what are the exclusive rights that as the copyright owner you would have. Next slide. just to give you a little perspective of how long a history copyright has existed, not just here in the United States. So as an origin of the copyright, it goes all the way back to England and the 18th century. And there were writers that I'm sure you're aware of, Dickens and others, who really took advantage, had the benefit of copyright protection in England. They were a little annoyed with the colonists, us, or who would reproduce without asking permission. But nonetheless, it goes all the way back to England. And the founders of our country considered it so important that it was written into the Constitution as one of the powers of Congress. And so I'm going to read you this. It's a small section, but Congress shall have power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this section also applies to patents. So in the United States, it's the federal government that gets to legislate and regulate copyright and patents. Now, the major law that we all work from it was passed in 1976, the Copyright Act, and it has subsequently been amended. Next slide. Now, we know there's exclusive rights, but how do you get the rights? And that's how are rights in copyright created and protected. Now, what certain words that I'd be using are important words. They may have a different meaning than what would be technically the way we would just use it in normal language or English, but because they have a special meaning, a lot of them have been litigated a long time to arrive at, well, what do these words mean? So in the United States, these copyright rights that we've talked about, they automatically attach. You automatically get them once you've fixed the work in a tangible medium of expression and provided that the work meets certain minimum standards. So again, it's automatically attaches. It doesn't require you to do anything special, although we'll talk about what things you can do. And it has to be in a fixed medium. It can't just be in your head. It can't just be an idea. Now, if we look at, well, what kind of works can be protected by copyright? And here we have the list that's out of the statute, and the major one of literary works. So plays, books, comic books even, but that includes software. So even though we can't read the code, that doesn't mean that it's not protected. The author of the code is not protected by copyright. Musical works, dramatic works, pictorial and graphic works. And an example of that is like a website. And so the look and the feel that you get from your web pages. Motion pictures and sound recordings. Next slide. Now, to reiterate, what is protected by copyright, those exclusive rights, is the expression of the idea, not the idea itself. And what I mean by that is, or an example would be, if you were going to draw a tree and I was standing next to you and I draw the same tree, but we're both looking at the tree, clearly our drawings are going to look similar. But in that instance, I didn't copy from you and you didn't copy from me. So that's how it is that it's original to the author, and it's not merely an idea, but there's something that's fixed. Plus, there's a low level of creativity that's required. So you wouldn't just have an alphabetical list of something and claim copyright in that. Next slide, please. So we now know, well, what is protected by copyright? So what does copyright not cover? And it's ideas, procedures, systems, methods, etc. Those kinds of activities or intellectual property, to protect it, you'd need to look to patents, which we're going to talk a little bit about, and trade secrets. They're not that kind of, the ideas and the procedures are not the subject of, available under copyright protection. And then works that are in the public domain. And so, for example, as we said, the copyright is for a limited period of time. Once that time expires, then the work is in the public domain. Next slide, please. Now, copyright in the United States started out, maybe it was for 8 years or 10 years, I'm not sure exactly, but a relatively small number of years. And then over the course of time, through different acts and statutes that Congress passed, the term of copyright has expanded considerably. And so in the case of an individual, it's going to be the life of that individual plus 70 years. So once the person passes away, there will still be rights in the copyright that are inherited by someone. And therefore, if you've got anything really great, you probably should attend to it in your will. Aside from individuals, if the entity, if an employer, for instance, is considered the author, then it's going to be 95 years from publication. Next slide. Now, we say that it's an author, a creator, and clearly that if you're in the create something original, artistic, even doodles, or even the notes you might be taking as we're progressing through this webinar, immediately copyright has attached because you fixed them in a way that other people can see them. So you would think possibly an employee, they're the creator of a memo, of whatever a particular work is. But no, in that circumstance, what the employee has done is considered a work made for hire. And so from the get-go, the employer owns it. Now, this term of a work made for hire is not just limited to working with employees or the work created by employees, but it can be if you're contracting with a third party to create something for you. And if that work comes within a category, so for instance, an important one would be films, it could be like a motion picture, it could be a collective work where somebody pulls together a bunch of short stories. So in those instances, provided the person who originally created the work agreed in a writing that the work was a work made for hire, then whoever is paying for that work ends up with the ownership of the copyright. Now, if the independent contractor's work is not within these stated categories, then you need to, at the time of contracting with that contractor, have an agreement in place that says that they are assigning their rights to you, to the employer, whoever is paying for that work. So an example would be an artist is painting a picture and you buy the picture, but that doesn't mean you have purchased the copyright in the picture. What you've done is you now own the physical item, but you do not have those exclusive rights to make copies of it, to display it in the public, and so forth. So that's why if you are interested and need to have the copyright, then you need to have a writing. And finally, by inheritance, which we said for the life of the author plus 70 years, there's going to be a long time, conceivably, that the copyright exists. Next slide. Now, as I had said earlier, copyright attaches immediately. You don't have to do anything special. But it is helpful if you put a notice on the work, which you're telling people, I'm asserting copyright ownership in this particular work. So if somebody then copies or does something with your work without your permission, and you want to go after them for this infringement, by having that notice there, it goes a long way to prove that they willfully infringed. In other cases, it may deter some potential infringers. They see that you've taken the time, they're now on notice, so they back off. Now, what you would do is put the copyright notice on a published edition. And as each edition occurs, there could be subsequent registrations and so forth, or editions, but you would want to have that notice there. And what does the notice consist of? A copyright symbol, well known as the C in a circle, but you can write out the word copyright or an abbreviation, COPR, period, plus the year of the publication, plus the name of the person who owns the copyright. Next slide. Now, why, if I already own the copyright, why do I need to do anything else? And of course, the anything else is to register the work with the Copyright Office. Now, as I said, registration is not required for protection, for you to claim your ownership rights. But if you're going to seriously enforce them, then you need to do that. And as I said earlier, copyright is regulated by the federal government, and federal courts, in order for them to have jurisdiction, can only examine and look at a case where the work has been registered. So why you would do it is you can't file a lawsuit to enforce it without having registered. Having registered, you're indicating some information, and therefore certain proofs are easier for you to make. And if you register the copyright prior to an infringement occurring, then you can claim what they call statutory damages as well as attorney fees. Now, the attorney fees are not necessarily a given, but at least you can ask. Next slide. Okay, so now we've looked at copyright in a broad way. So what does infringement mean? What is copyright infringement? Well, it's when someone other than the copyright owner exercises one of the exclusive rights without the permission of the owner. In that case, they're an infringer. Okay, so now let's move to the next subject. Oh, I guess I got ahead of myself. So now you're faced with an infringer, so what may you do? Well, you can certainly send them a letter putting them on notice. They need to cease and desist. You may enter into some kind of a settlement with them where they pay you a licensing fee. But if you're forced to go into court, you can ask to have them enjoined from using the work further. You can ask for actual damages. We talked about statutory damages and attorney fees, but those latter are only if the infringement occurred after registration. Next slide. Okay, now we're moving into the next big topic, which is what is a trademark or a service mark. And not that these words are interchangeable, but people tend to group and everything comes under trademark. But literally, a trademark is with respect to goods, and a service mark is a mark you use in conjunction with your services. So what can stand as a mark? And you can have a word or just letters. It could be a design, but it even could be a sound. There's anything that people see consistently and they come to identify whatever that is with the product or services, then it becomes or it takes on the characteristics of a mark. But the mark always has to be used in connection with the business or enterprise. And so nonprofits, for instance, they're eligible to have trademarks as well. Next slide. So, okay, well, great. I'm going to have a trademark, but why do I have a trademark? And it's a very important piece of intellectual property. First of all, by using it, you're telegraphing or speaking to the public so they will not be confused by the source of the goods or services that they're purchasing. They want to know that it's come from X and not possibly Y and Z. Likewise, the business itself is then able to distinguish itself from its competitors. Nobody is putting out a goods or service that's just a one-off. We all have to be dealing with competitors. But by noting that this is my goods, my services, and I have a level of quality that you as the purchaser or consumer have come to expect. So I'm different from my competitors, and that's what the mark helps you stand out. And it also prevents others from taking what they call a free ride on your goodwill. So after you've built up all the goodwill, so to speak, of your product, you don't want somebody else coming along and using a mark that looks a lot like yours and fooling people, confusing them as to what was the source of the product or service. Next slide. Okay, so what do you get when you have a trademark? Similar to copyright, you get an exclusive right. Exclusive is exclusive, and it's the right to use the mark with your goods or services. And we can imagine that the trademark can become a valuable business asset. It's a form of property. So if you're going to sell your business, people that are going to buy the business would want to acquire any marks, the ownership in any marks that you used. And so since it's a piece of property, it can be bought, sold, or in most instances, licensed. Next slide. Unlike copyright and patents, which are federally regulated, in the area of trademark, there's a combination. It can be protected under federal law. It can also be protected under state law. And that grows out of what's called the common law. So court decisions that have been ruled in even as far back as we said to the English common law. When you are using a mark that is not a federally registered mark, then you might want to place the TM or an SM near the mark, because then that's putting people on notice. Hey, I claim this as my mark, so don't mess with me. Now, certain states in the country also let you register with them. And so, for example, we have Virginia and Maryland in this area, but not the District of Columbia. If you are in a position to register the mark with the federal government, then once you have that certification, you're able to use the R with the circle. But in the case of federal to have a federally registered mark, the mark must be used in interstate commerce, which means across state lines. Next slide. Okay, so as I said earlier, a lot of things can be serve the purpose of being a mark. So we're all familiar with words. We have apple, and that's a famous word. Question is, if I say apple, do you think of the fruit or do you think of the company and the products that they offer? It could even be a series of letters. So lots of networks, NBC, TNT, FX, all of those have acquired mark characteristics for the organizations they're with. Even a series of numbers can come to stand for, let's say, a particular model of car. Another source of marks are logos, and they tend to be pictures, designs, or symbols. And so a good example of a picture is if you purchase Sun-made raisins, you're going to see on the box a picture of a young girl with a basket of raisins. In the case of a design, let's say it could be Burberry's plaid. So other people that are selling the linings that go in raincoats or something, they cannot be looking like Burberry plaid. A very famous symbol is Nike's swoosh. You just see the swoosh and you immediately think of Nike. Now, it took Nike a long time to get to that state. They didn't have that kind of recognition from the beginning, but in all cases, these people and organizations pay a lot of money to keep enforcing in your mind that this is their mark. Another mark might be a name. So it's not for the name's sake, but let's say in the case of Dell, the computer company, it's come to be associated with their product. It's not the name of their corporation per se. It's associated, excuse me, with their product. Now, another important area are franchised restaurant or other kind of franchised organizations, which have a theme. So when you walk into a McDonald's or any of the other well-known ones, the look and the feel of the place lets you know I'm in a McDonald's. And so another franchisor wouldn't be able to make their locations look confusingly similar to that of McDonald's. Next slide. Okay, so those of you who are in business already or thinking about it, what do you do before you adopt the mark? So one thing is, once you've come up with something, it would be really important and a good idea to search, because it's really hard to come up with something that's totally original. So you want to look out there, you want to check on Google, you want to know in your industry or your competitors, anything that would contradict or conflict with what it is you're choosing or wanting to adopt. So that's important. And it's better to know now rather than a year later when you've spent a lot of money. So you want to find that out. And if you hire a professional searcher, they're going to go to the USPTO, the Patent and Trademark Office, and they're going to search for existing marks, canceled marks, those that are in the process of being applied for, and then be able to see or rule out that there isn't somebody else that's already in the process of getting a federal registration that's going to be offering similar goods and services to you. They'll also look at what's the common law marks, and those could be the state registrations. And then because of a design element that would appear in the logo, you also want to be sure that your logo doesn't pick up on somebody else's copyrighted protected material. Next slide. Okay, so now you've decided where I've identified it. So now I want to register my mark. And so we've conducted the search. And in the application, you're going to have to identify the goods or services and/or, can be both, that you're offering. You have to identify them and have them in a certain what's called an international class. And there's maybe 34 classes that are dedicated to goods and 10 that are dedicated to services. Then you're going to need to tell the PTO when you first used the mark and when was the first time it got used in interstate commerce. You identify who is the owner. In the case of a logo, you'll provide that. Now, the filing fee per mark, per class is $400. So if it turned out that what you were offering is a mark that is available for your goods, but also services, let's say you're the upkeep or maintenance of the product, then your filing fee would be 400 times 2, $800. Next slide. Now, in the case of trademark, federally registered trademark, the terms run in 10-year increments. And so if you renew it and you follow what's necessary you continuously use it, you maintain it according to what the PTO wants, then this can go on for a very long time. But if you fail to pay the fees or the filings that are necessary, then the USPTO would consider the mark abandoned. However, it doesn't mean that it's not a mark. It's just not going to be considered a federally registered mark. Next slide. Now, how do you go about protecting your mark? Well, an important thing is to continuously use the mark in connection with your goods or services. And if you have to overdo it in the beginning, fine, because you want to align in the mind of the consumer your mark and your goods or services. You need to police your mark to be sure that people out there aren't already trying to copy it in some way or use it inappropriately. Now, if you license your mark and allow a third party to be able to use it, you want to be sure that you're checking up on them, that they're living up to the quality levels that you expect the mark to have, because otherwise they're going to cause you to lose goodwill. If there are infringements, then you want to address them. And of course, we want to comply with the requirements of the USPTO. Next slide. Okay, so we've now covered in a quick way trademarks. And now another big area is patents. So what is a patent and who issues it? In the United States, a patent gives the person who is the owner of the patent, they have the right to exclude others from making, using, selling, importing, or offering an invention for sale, but it's over a fixed period of time. So the owner of the patent would have the right to sue those who take any of those kinds of actions without permission. As we noted, patents are covered in the Constitution, and it's the United States Patent and Trademark Office, their patent side of the aisle, that regulates it. Now, there are three main types of patents: utility, design, and plant. We're just going to talk about utility and design. Next slide. So what is a utility patent? Well, in order to qualify to apply, not just apply, but to receive the patent rights for a utility, the invention must come within statutory subject matter. And in order for it to do that, it has to pass certain tests. So, for instance, it has to be a process, a machine, article of manufacture, composition of matter, or a new use of one of those. It must be useful, functional, and it must be novel. So it's different in some way from all of the prior art and knowledge. And it must be what they call non-obvious. And what that means is that from the point of view of someone who has ordinary skill in a particular technology, that they wouldn't see as this invention as being obvious from something that was invented earlier. Now, as I've read, and as you can see on the slide, I've highlighted certain words. These all have special meanings that have been highly litigated. Next slide. So the upside of having a utility patent is you have this exclusivity. You're able to prohibit others from making, using, selling, or importing. You get that exclusivity for 20 years, and it's from the application filing date. And your invention, it doesn't have to just have one claim, but it can have multiple claims of how you're describing what the invention is. Now, the downside is that while the patent allows the owner to prohibit others, it doesn't authorize the owner to do any of those activities. And so frequently the owner can be challenged because somebody else comes along and says, well, your invention supposedly is infringing on mine. They can be very expensive, not only to obtain, but to enforce. There are ongoing maintenance fees with the USPTO during that 20-year period, and it can take between 2 and 3 years to actually get the patent issued. Next slide. Now, that's giving you encapsulating a utility patent. So what is a design patent? Unlike a utility patent, it doesn't have any usefulness. Rather, it's focused on ornamentation. So a patent may be issued for a design that exists on a non-natural object, which is unique, ornamental, or covers the visible shape of the object. It's purely ornamental, purely aesthetic. It isn't something that the object needs to have in order to function. So if the shape at all, or whatever this ornamentation is, at all contributes to the functionality, then it's not going to be eligible for a design patent. And in the case of design patents, it's 15 years of exclusivity from the date when the patent was granted. Next slide. Now, I found this. This is the patent that was issued for the original Coca-Cola bottle. It's a design patent. It was issued in 1915. Clearly, it's elapsed. So for purposes of design patent, that's not available. But of course, the object has become so ingrained in our psyche that it has taken on trademark and even conceivably copyright implications. But this is an example of it's the design that you submit. It's the drawings. Next slide. The upsides and downsides for design patent. Well, you don't have maintenance fees, so that's a good thing. And as I said, it could be protectable under your design could be protectable under other kinds of law. You only have to make one claim, and it's what the claim is what the drawing, and it's a relatively short time for approval. A downside is that it offers a very limited scope of protection because it's just what the drawings portray. And so it's easy for a competitor to design around your design. And so it's hard to enforce, and enforcement is costly. Next slide. This shows you a comparison of some of the fees between a utility as opposed to a design patent. So for instance, in the filing for utility, if you're considered a small entity, then your filing fee would be $140. But if you're not a small entity, then it's $280. Similarly, with a design patent, it starts at $90 for small entities, $180 for larger ones. Next slide. Now, similarly, or somewhat similar to the concept of ideas and processes and methods that can be covered by patents, that's trade secrets come in, because we know after a while a patent expires, then whatever the invention is, it's now in the public domain. But if you're able to maintain a concept, an approach, a method, and you're able to keep it secret, then it acquires certain kinds of rights as well. So a definition for trade secret is any valuable information that you've accumulated, discovered, developed, or generated in connection with the operation of your business that is not generally known and for which you take reasonable steps to preserve the secrecy. So it's processes that are not generally known and that you've taken reasonable steps to preserve the secrecy. Next slide. Examples of trade secrets, and we can look at these. None of these are rocket science, but you have customer and supplier lists, your business and marketing plan, software that you specifically had developed for you, or you've developed internal procedures, or you have techniques and systems. So all of these you want to keep protected and not have your competitors know about it. And so it's can be considered a trade secret. Next slide. Are there time limits on a trade secret? No, unlike patents and copyright, and even in the sense trademarks. As long as you keep the secret, then these rights in the trade secret exists. And so, for instance, you can think of the formula for Coca-Cola. It originated back in 1886. Likewise, the recipe for Kentucky Fried Chicken in 1940. Those secrets have been kept, and they can go on and on and on. Next slide. So what steps do you need to take in order to assert that you have trade secrets and you want to protect them? What would be important is to really identify what is a true secret, a trade secret. You're not going to protect everything. You want to find out or identify what is really important. You might stamp confidential, the word confidential, on the item. You want to have your employees and consultants sign confidentiality agreements, also called NDRs, non-disclosure. And because once they leave your working, you need them, your employment, you need them not to be sharing this information they've acquired. You lock away sensitive materials. You set up firewalls and passwords with your devices. You limit access to only those who need to know. And you enforce and faithfully follow these procedures. You don't just have them in a guidebook and then not enforce them. Next slide. There is a law of trade secrets. It's state law, although the federal government has some trade secret legislation as well. But the immediate jurisdictions, Maryland, Virginia, and the District of Columbia, have adopted what is called the Uniform Trade Secrets Act. And courts also get to influence the law because they've gotten to comment upon, well, what the different terms mean. Next slide. So you've taken steps to protect your trade secret, but nonetheless, somebody misappropriates it. So what do? Well, first of all, you want to figure out, well, what is misappropriation? And it means that someone acquired the trade secret of another improperly, or disclosed or used it in any instance without permission of the owner of the trade secret. Okay, so now we've identified what it is, and you can seek injunctive relief. You can look for actual damages, unjust enrichment. As part of a settlement, you might seek to have them pay a reasonable royalty, etc. Now, it's also possible that you could claim attorney's fees, but that's not always a necessary given. Next slide. So we have trade secrets, and we talked about confidentiality agreements, but another is non-disclosure agreements. Likewise, there's another type of agreement, a non-compete agreement. So these are agreements that you can use to further protect your intellectual property. Next slide. So how does a non-disclosure agreement work? Well, the NDA would require all who come in contact with the information, the trade secret, the confidential information, to be under a legal obligation not to disclose it or use the trade secret without your permission. So in the case of an employee, while they're your employee, they're legally obligated. But if they're not subject to a non-disclosure agreement, when they leave you, they're not bound. You want to incorporate such agreements in other agreements, not just limited to employees. So it could be a buyer or seller in connection with the business, contractors, consultants, anybody who's going to have access to these important trade secrets. But you want to craft the language of the agreement as narrowly as you can, because otherwise, if it's too broad, then it's going to be difficult to enforce. Next slide. Okay, so we had non-disclosure, but what about non-compete? Well, if you're going to have, let's say, an employee or some other third party not compete with you once, and even though they're getting access to your important secrets, they have to have signed the agreement prior to having access. Otherwise, you can't stop them. So basically, you're going to want to protect trade secrets. But keep in mind, in the United States law, it's competition is the high point. That's what needs to, or is the focus in the United States. So some states are particularly hostile, like in case of California, that such agreements would be void. And courts are more likely to enforce the trade secret, the non-disclosure, as opposed to the non-compete. So in drafting a non-compete, you really want to hone in and have it as limited as possible. Next slide. What is a license? Well, with a lot of the intellectual property we talked about, you're allowing other people to use it, but under license. So these other people or businesses, they have permission to use the IP, but within limits. And so if they go outside the limits, let's say they had XY, but they do Z, then they would be guilty of infringement. Next slide. So are you a licensor or a licensee? Well, if you own the IP, you would be considered the licensor, and it's something like a landlord. If you want to use somebody else's IP, then you're going to be the licensee, and it's similar to being a tenant. Next slide. So why would you license your IP? Well, that way you don't lose control over it. You haven't just sold it, but you haven't lost control. You may be able to recoup your development costs. And in the case of the licensee, you're only paying for what you use, and you rely on the licensor to update when necessary. Next slide. What models use licenses? Well, franchise businesses, publishers and authors, all of us, when we're using anybody's software for our devices, all of that's under license. Next slide. So the bottom line is that you want to inventory the IP, the intellectual property that you own, and what you are using, not just what you own, but also what you're using that is owned by someone else. And be sure to have well-written agreements in place. That will go a long way to prevent needless and costly disputes from arising. Well, thank you very much. And here's some links or suggestions. These government entities have really good websites with a lot of information. So, next slide.
Okay, 1 second. I do have some questions. Barbara, can you hear me okay?
Yeah, I'm sorry that this ran into, but...
Oh, no, that's okay. So let's start with Andrea asks, what exactly does published edition mean? Does it have to be public to be copyrighted or registered?
Well, published does mean that it's out there in the public. It's not your diary. So even though, let's say, copyright attaches to your diary, because clearly you've written something, you've set it down, but it's not eligible to have copyright registration because it's not published. It's not put out there so others can see it.
Okay. Sherry asks, can you adopt an abandoned mark? What kind of protection does an abandoned mark still have?
Well, keep in mind with an abandoned mark, that doesn't say the person isn't using it with their trade or business. It just means that they didn't continue to pay the fees or keep up the maintenance with the USPTO. So while it may not be considered a registered mark, it doesn't say that it's not a valid mark. And so you'd want to go very cautiously and not assume anything about a mark that somebody claims is abandoned, because for all you know, it may not be abandoned. Like in the case of the bottle, the Coca-Cola bottle. Now they no longer sell Coca-Cola or very little in the bottle, but they've got that bottle everywhere, and occasionally they bring out Coca-Cola bottles and sell them. So you want to be really careful.
Okay. If you had a trademark and it expired, can you reactivate it, or do you have to start the process all over again?
Well, I'm not sure I understand about expire. If you don't comply with, I'm sorry, what?
I'm assuming it's about like if it's been abandoned, like they didn't pay up the fees after the 10-year mark.
Okay. Well, again, there's little grace periods that the trademark office offers, so that if you miss a deadline for the maintenance fee, you pay a little extra, and typically it's within 6 months or 90 days. But once those times pass, if you want to reactivate and have a federally registered mark, you'd have to go through the process.
Okay. Next question from Brianna. I'm currently doing a smaller scale Shark Tank-like competition. My business is not incorporated yet as far as protecting the ideas and name of my business while doing these type of competitions. What is the best way to protect my ideas and my company?
Well, again, ideas are there, I often say, there to be stolen unless you've taken appropriate steps that either have people enter into confidentiality, you limit access, you have them sign agreements. If you're doing this activity out in the public, clearly, whatever those ideas are, everybody gets to see them, and you're not in a position to tell your public, don't copy this. Now, again, if there's materials that you hand out and you've created them, then as we said, copyright rights have attached. So if you found people copying or using those without your permission, you could assert copyright. But then again, in order to be effective, you have to have registered the copyright.
Okay. Sherry asked, for patents, when you say it's good for 20 years from filing date, does that mean provisional patent filing date or non-provisional patent filing date?
I'm not sure. The provisional is only good for a year, and then you actually have to either file. So my sense is it would be from the filing date, not that provisional, because the provisional is good for a year, but it evaporates. So the concept is that if it takes you 3 years to get the patent, then you're only going to have the exclusivity for 17 years.
Okay, only a few more questions. If I'm holding a conference or summit, can I have potential speakers sign an NDR when I'm vetting them for speaking at the event?
Well, if in the planning of your event and you don't want to get the word out, in limited circumstances, yes, if they're willing to sign it, that's great. But keep in mind, it's not going to be enforceable once whatever this information, once you've made it public, goes out there. And so in that case, it would just be for a limited period of time until you've launched whatever that project is.
Okay. Then we have one more question. It's a two-part. Say a photographer captures a photograph of a shadow, the shadow on the ground, for example, of copyright protected 3D object, let's say Rodin's The Thinker sculpture. The photograph does not have included a sculpture, only a shadow implies Rodin's sculpture. Is the photograph an original work of art?
Well, that's an interesting thing. First of all, the Rodin, that's outside of copyright protection. It's many, many years ago. But that's a very interesting question. So since it's in the public domain, it would seem to me that you could take a picture of the shadow, and it definitely has artistic elements to it. Somebody else might take a picture of a Rodin, and the same Rodin statue, but from another angle. So you wouldn't be able to claim that that second person was infringing on the copyright of your art. But if you later saw, let's say, calendars, and there were pictures and they were showing shadows, and one of them was this picture of what you took with Rodin of the Rodin statue, well, then they would have been infringing your copyright.
Okay.
Because there's definitely an element of originality that came from you. You got the great idea to look at it from the shadow point of view, etc.
Okay. And the question is, can you license or lease a trade secret? What is the difference between them, license versus lease?
Well, it's a license. A lease is usually associated, as I say, with rental and so forth. But, they have a common background. So, I'm sorry, could you say the question again?
Yes, it said, can you license or lease a trade secret? What is the difference between them, license versus lease?
Okay, you can definitely license a trade secret, similar to having your employees sign non-disclosure confidentiality agreements about your secrets. If you're letting somebody use it. It's under license. They don't have the right to be able to publicize it or use it in a way that you haven't structured in the context of this licensing agreement. So you definitely can do that. Now, if separately they're able to come up with the same kind of information and not be relying on what you offered them, then they're free to do that. So you really have to be very careful in the structuring of those kinds of agreements. And probably as best as you can, you want to have these independent contractors, customers, etc., not have ready access to what you consider are your trade secrets.
Okay, and one final question, and then we'll wrap it up. How does the FTC reporting or complaint filings work in regards to trademarks and patents as well as ownership?
I'm not sure I understand the question.
Okay.
The Federal Trade Commission doesn't regulate the. I mean, they deal with people not not telling the consumer the truth or something about it.
Okay.
So I don't know that I can answer the question.
Okay. Maybe that's something they can contact you about. It was from Joy. So
Okay.
That's all of our questions. We thank you guys for joining us today. Ms. Berschler's information is on the screen. She's located in Rockville, Maryland, and her phone number is 301-963-8580. Or you can also visit her website, www.berschlerlaw.com.
One thing, it should be 962.
Okay.
I can't believe I gave the wrong.
That's 301-962-8580, and we'll make sure we have that corrected number within the replay. Again, you will receive the replay within 24 hours. It was a lot of great information, and that way you can actually listen to the replays as many times as you need to, and we'll also be sending a survey at the end. Did you have anything else, Barbara?
No, I'm just thrilled to have had the chance to do it, and I do hope this information proves useful to those that are in business or are thinking of having a business.
Great. Wonderful. Well, we thank you again for taking your time out of your afternoon to spend with us. The replay will be sent to you within 24 hours, and we hope you have a great day. Bye-bye.